Good evening, ladies and gentlemen who have joined us on this Dr. Fundi channel, joining us via multiple social media platforms, via Facebook, YouTube, Instagram, and Twitter. Welcome to all of you. Today, we have a very interesting discussion in prospect or conversation. Today, we are tackling something that has been on many people's, minds and lips for the past week or so. For those people who are here in Gauteng, they will know that on Tuesday, on the Star newspaper, which is, one of the leading newspapers here in Johannesburg. So the headline was "No jab, no job." No jab, no job. And this was referring to the Department of Basic Education that has threatened to invoke operational requirements and incapacity clauses of the Labor Relations Act against those teachers who are opting not to vaccinate. There's a circular that the DG, Matanzi Mamweli, sent to schools on the previous Friday. And basically, that circular says the department reserves its right to deal with teachers who are choosing not to vaccinate on constitutional, medical, religious, or cultural grounds. Now, there are many other newspapers that have talked about the same. Also, COSATU has also started weighing in on the issue, almost saying the employers must, understand. They mustn't go, to the route of, taking disciplinary steps against those teachers who have opted not to vaccinate. So there's been a lot of discussions pro or against this stance that DBE has taken. And many of us who've been commenting on this are lay people when it comes to matters of law, especially employment law. So who better than to come and help us than somebody who is an expert on employment law? So today, I have invited an old friend, I'll call him a business associate as well, because it's not the first time that, I've known him for more than 5 years now from this space of employment law. We have used him extensively in my company, Proactive Health Solutions, for a variety of things. And so I'm going to introduce to you our special guest, Mr. Bongani Masuku. Right? So Mr. Bongani Masuku is a director at a big law firm here in Sandton called Clive Dekk Hofmeyer Incorporated. He joined them as a director in October last year. But before then, he's got a long history, of being within this space. He's an experienced attorney with a lot of history working in the law practice industry. He's skilled in legal advice, in corporate law, in employment law, in court litigation, in arbitration proceedings. Generally, this is somebody who's got depth and breadth when it comes to issues of the law, especially employment law. He qualified, as a legal professional with an LLB from Wits University. That's about 13 years ago. And he has worked himself up from being a judge associate at DOJ and CD, that's constitutional development. Worked himself through as a candidate attorney at WM Incorporated, and also as an associate attorney in the same firm. And then later He then, worked for a firm called Tapax, that's in Parktown, and he spent, I think, about 7 years there. And last year, he moved briefly to another law firm called Lawton's, but he was snapped by Clive Dekk and Hofmeyer. So we are going to be informed, to be educated by somebody who sleeps, eats, and drinks employment law. He's shy as I'm talking about him. He doesn't like it, but I mean, the man has got the depth and the breadth of knowledge, and we need to be informed, because in social media, we tend to make commentary on things that sometimes we really don't have any understanding of. And so I hope by the end of this session today, many of us who had opinions will reevaluate those opinions from a point of understanding the relevant law. Mr. Bongani Masuku, welcome to Dr. Fundi channel.
Good evening, Dr. Nyati. Thank you for having me, and good evening to everybody watching this, streaming it all across the country. That was quite an interesting introduction for a man like me. Thank you for having me. Look forward to the discussion.
Many of us, especially those who come from Emakaya, we taught to have humility. So I understand, humility and why you don't want that long introduction, but it's okay. And nothing that I said there is not true. All right, Baba. You need to help us through.
Yes.
For the past week or two, the lay media has been talking about the issue of vaccination. We know that, for example, for the Gauteng Department of Education, out of about 90 to 100,000 employees, about 10,000 of them elected not to, vaccinate, in spite of the fact that as a sector, they were actually, given special, attention so that they can vaccinate, so that by the time schools reopen, they have been vaccinated.
Yes.
Now, Gauteng, education is not alone. There are many other, provincial departments, of education, where a number of teachers did not take up the offer from the employer to vaccinate.
Yes.
And so now we hear that DBE, Department of Basic Education, is actually thinking of bringing a stick for those who have chosen not to vaccinate. So we want you to help us understand, the competing rights here, between the employer and the employee, as far as refusal of vaccination is concerned. So maybe let's start with the employer. What are the obligations or responsibilities that the employer has as far as its employees and the workplace?
I'd say that's an interesting place to start, Dr. Nyati. It's very important that our watchers and listeners and streamers out there understand that there is a very important obligation, important and mandatory obligation that rests on all employers in terms of Section 8 of the Occupational Health and Safety Act, to create and maintain a safe working environment, or a working environment that is free from any health and safety hazards. And this is about creating first an environment and maintaining an environment for all current and future purposes. So the obligation is not only current, but it's also present and continuous in that sense. And there are some details that go into what that obligation actually entails. But I think the two things that I need to distinguish here, which I think are quite important, are the primary obligations that rest on all employers in terms of Section 8 in creating and maintaining a working environment that is free from any health and safety hazards. And what I think is a more secondary obligation in relation to that obligation from the Occupational Health and Safety Act. The primary obligation, Dr. Nyati, is that every single employer has an obligation to put in place or create as conducive an environment in their workplace for workplace health and safety as they possibly can under the circumstances. Obviously, this is the test applied here is a test of reasonableness, having regard to the nature of the employer, the nature of the workplace, a number of other issues that need to be taken into account, including the nature of the job functions that the persons perform, et cetera, et cetera. But obviously, what is a safe working environment for one type of an employer may differ from what is a safe working environment for another type of employer. So what the courts apply in this regard in relation to health and safety in the workplace and in relation to the obligations of the employer is really a substantive test of what is it that your environment entails, what is it that you do as a business that employs persons, and what are the job functions associated with the various job roles that your different employees would have at different levels. And then an inquiry can then be undertaken as to, well, have you as an employer done enough to meet your primary obligation to create first and maintain a safe working environment? And I say it's a primary obligation because it's about the environment that you create itself. The secondary responsibility is to ensure that you have all the necessary PPE for your employees, personal protective equipment, to ensure that you comply or you keep on complying with the obligation to maintain a working environment that is free from any health and safety hazards. So yes, the primary obligation is I think for me a major key focus for purposes of the present discussion, because by an environment, you create an environment through policies, you create an environment through the type of office space that you have, the type of floor plan that you might have, that all goes into an environment. And in my view, whether or not you adopt a mandatory vaccination policy also is something that is quite important relating to the nature of the environment itself. And that goes to the primary obligation of the employer. So that decision, that all-important decision that all employers have to take about, do we get our employees vaccinated through a mandatory vaccination policy? Or in other words, do we make vaccination in our workplace mandatory, forced, or do we make it on the basis of a person's choosing to either be vaccinated or not to be vaccinated? So in other words, based on consent. That's a very important decision, and that's a very important balancing act that every single employer who has Section 8 of the Occupational Health and Safety Act apply to them and their working environment has to actually grapple with. And obviously different results could come out from different types of workplaces and different types of businesses that employ persons. But what is important there is to know that you have to do everything that is reasonably within your power as an employer to create that environment and then to maintain that environment for current and future purposes. And that for me is a primary obligation, and that is quite an important thing.
Yes, you keep on talking about reasonableness, and I think at some point we're going to need to say, who decides on reasonableness, but yeah, I understand that. So there is that obligation on the employer to make sure that people do not get sick or acquire, infections or diseases in the course of them, working within that employer. All right.
Yes, of course.
So that's one. That's on the employer side.
Yes.
Now, so vaccination for COVID-19 obviously would be one of the tools that the employer is looking to use to then, if they've decided that this is a risk, because part of occupational health is to do a health risk assessment within your environment.
Absolutely.
Having done that health risk assessment, to then decide, are there risks that can be identified, communicate those risks, and do something about those risks. you know,
Absolutely.
and so if the employer has then decided that COVID-19 is a risk to their operations, to their business, to their, you know, operations and or their business, obviously, then when there is something that can mitigate that risk and that something is reasonable, then they should consider it. You know, what are your thoughts there?
Absolutely. So to answer the first question, Dr. Nyati, who decides, unfortunately for employers, is that you get judged on the basis of hindsight. And as we all know, hindsight is always a genius. But you get judged by the courts. You know, you might have cases where employees refuse to be vaccinated, in which case then you think as an employer that that is reasonable and that you want to implement that, and you find yourself before the courts having to convince a court why that is reasonable within the context of your employment, workplace and environment, right? So the courts will decide that issue. It might be that the courts have to decide the issue on, you know, on a different basis. For example, on the basis that you have not actually implemented a vaccination policy, and the employees challenge you. And they say, well, we think that it's not reasonable what you're doing, and that this is what we think should be done to protect us and to ensure that you comply with your primary obligation to create and maintain a safe working environment for us. And what you're doing is not reasonable. So then the question becomes a question of fact, really, more than anything else. Obviously, the legal principles applicable are those to be gleaned from the Occupational Health and Safety Act and the purpose for which the Occupational Health and Safety Act was even enacted in the first place. But as for the question of who decides reasonableness, it's definitely the courts. And what is reasonable, which is the next question, is obviously something that depends one employer to the next. It's a factual inquiry that will have to be undertaken by every single employer. And thank goodness for the new consolidated directive on health and safety that actually expressly permits employers to consider implementing mandatory vaccination policies. For the first time, we saw the government actually not sitting on the fence on this and saying, well, we think that you can go ahead and do this because we see, you know, what is happening all across the country and all across the globe. So what you will have to look at to decide what's reasonable and what's not is really the facts on the ground per each and every employer's special circumstances that are applicable. So, for example, if we have to take it home to the Department of Basic Education, for example, I would think that teachers are people that ordinarily by nature come into contact, direct physical contact with learners, our children. They come into direct physical contact with one another while they're in the staff rooms and, you know, rubbing shoulders, rubbing elbows and all of that, and staff meetings and all of those things. They may come into contact with learners and one another as educators in sporting events, extracurricular events that the schools have. So on the basis of the very intensive physical contact that exists just by the inherent nature of the working environment being a teaching and learning environment, you can already immediately see how obvious it is that that is a ripe environment for something like COVID-19 or any different variant of it to actually thrive, and for infections to skyrocket because people are in unavoidable physical contact. You know, I cannot imagine if you know, an institution of basic learning and teaching and learning, you know, being able to convince any court that the level of physical contact between teachers amongst themselves and cross-pollinating between teachers and learners is such that the risk of infection is low. You know, so I think it's, from a common sense approach, I think it's commonsensical that there's the level of physical contact involved in any teaching and learning, especially you know, at a level of basic education, you know, creates a ripe environment for infections to rise. And unfortunately, with infection comes illness, and sometimes comes complications and even fatalities. So, you know, that if we were to use that as an example, I would think that, you know, that risk assessment that the Department of Basic Education would have to have gone through would necessarily signal to them that we are a high-risk area, without question.
In fact, after the second wave, well, not by November, December last year, that is when the second wave was just starting, when the department had to close schools for 2020, they had reported something like 1,490 teachers who had perished from COVID-19.
Yes.
And that
Yes.
is just in 2020, you know. And then we had the second wave at the beginning of the year. We have the third wave right now. So those numbers, I'm sure they have grown from that number of plus minus 1.5 from last year. And
Absolutely.
any employer should actually take that risk seriously, because there are people who are dying.
Absolutely.
Yes. Now, what I want to find out from you before we get to the other side, which is the employees. Now, at the beginning of the year, our president announced that vaccination will be voluntary.
Yes.
All right, for all people in South Africa. So others are then saying, but the president said no one will be forced to be vaccinated. But
Yes.
now DBE and other employers, having done their own health risk assessments, are actually saying we are going to force people to vaccinate. So how do we marry those two?
So the first, I think we need to differentiate two things here, Dr. Nyati. The first is the words of the president come to us as ordinary citizens, mostly, and I suspect that we probably want to quarantine the president's words in that regard to, him just saying nobody, as who's a member of this population outside of an employment relationship will be forced to be vaccinated. That's the first way in which I understood him, when those words were uttered. And obviously, if we take it into the employment context and we try to interpret his words there, I also understood earlier that, and that was before the most recent consolidated directive that we have now.
Yeah.
Well, I understood that the government was adopting a more voluntarist approach to COVID-19 vaccinations. And that was seemingly all across the board, whether he speaks to us as, ordinary citizens, or whether he speaks to us as businesses running, having employees and employees being employed by those businesses.
Yes.
The approach was certainly one of voluntarism, and you had to opt to be vaccinated. And I suspect, this is pure conjecture, it was on the basis of the widespread, rumors, maybe even stigma around what the vaccination can or cannot do.
Yeah.
And the rumors that went all across the country and probably across the globe as well about, all sorts of things that people were saying about the vaccination. Some people even saying, referring to Satanism,
Yeah.
some people referring to.
Yes.
It got a bit ridiculous at some point, I must say.
Triple six and the mark of the beast and things like that. Yeah.
Yeah, you're facing certain death and you're thinking about Satanism. But I don't look down on people's, with that comment, I don't look down on people's beliefs, because, people sometimes genuinely hold those beliefs. But I think the approach from government was certainly one that was voluntarist.
Yeah.
And now the change in the consolidated directive is to permit rather than to say you must do this. So it's not mandatory. It says you may look at implementing a vaccination policy that forces your employees to get vaccinated even. And obviously there'll be consequences for those employees who refuse to be so vaccinated if the vaccination is mandatory in the workplace. So if you introduce a vaccination policy in the workplace, that vaccination policy is valid and binding and is applicable to all your employees. And if that mandatory vaccination policy calls for all your employees to be vaccinated before returning to work, for example, then that's applicable. That's the term and condition of employment. And if you breach that term and condition of employment, there could be consequences, including some serious and dire consequences for any employee. So I think the change is really informed first by a study of what we've been through in about 18 months or just over that, since about March last year, the 26th, and the different variants that we keep getting of the virus that just keeps springing up on us as a country and as a globe that nobody is ready for, and the rate of infection the rate of transmission, as well as the rate of fatalities being extremely high, I think government had to find a way to bridge the gap between voluntarism and enabling employers, or communicating clearly to employers to say, actually, despite what we think should be a voluntarist-based approach, you have a different set of obligations applicable to you as we do as government towards our people, right? And those obligations extend to those obligations that I've discussed in part in terms of the Occupational Health and Safety Act. And insofar as some of them carry with them a lot of stick, because they do carry a lot of stick, people like yourself, CEOs, can find themselves being imprisoned for a breach of the obligations carried in the Occupational Health and Safety Act. Other than the fines, and the hefty fines that can actually be levied from the businesses. So there's quite a stick that the Occupational Health and Safety Act can wield, for employers and for businesses if they don't comply with their obligations, or if they are found to have complied with their obligations in a manner that was not reasonable, or have done less than what would have been reasonable under the circumstances. And I think that probably explains the changing tone. But I don't necessarily interpret the president's words and this change in the new consolidated directive to mean that we've gone 360. I think what it means is that we are responding to a different set of facts and circumstances that are on the ground and applicable now, that perhaps were not applicable some 18 months ago.
Yeah. All right. So we're going to get to now the other side of this thing, which is the employees and the rights of employees. All right. But before we do that, anybody who is watching us and they've got a burning question, whether they're watching us via Facebook or YouTube, feel free to just drop us that comment or question. My colleague Nwabisa will be able to pick it up from Facebook or YouTube, and we will then pick up those questions and ask Mr. Masuku to comment. Obviously, we may not be, if there's a flood of questions, we may not be able to answer all of them, but just to get a sense, of what people are thinking on this subject. I remember this morning, I was going through somebody else's timeline, a guy called Pule Munaba, who's my Facebook friend. And I actually said to him, at 18 hours, we are going to be discussing this matter. And his issue at the time was, why are we only just focusing on those who are refusing? What about those who have already vaccinated? What about their rights, to be protected in the workplace? What about their rights? Because now we're just talking about those who are refusing, they've got rights and this and that. But even the ones who are vaccinated, who took the decision to vaccinate because they wanted to be protected. So how can an employer then allow other people who have opted not to vaccinate, because then they pose a risk to them, because the vaccine does not completely eliminate the possibility of infection. What it almost guarantees is that if you do get infected, then it may be a milder version. But, so one must look at both sides. So we are told here then that some of the employees from GBE on constitutional, medical, religious, and cultural grounds, they are saying no to vaccination. Now, I think those are coming from the Constitution. Maybe can you just take us through, do they have a point, these guys, that I've got rights, right to bodily integrity and this and that and that, and so no one can force me to actually take a vaccine because my Constitution protects me. So can you just talk to us around that?
All right. So maybe let's just take a detour a little bit and deal with Mr. Pule's comment on Facebook. I think with that, Dr. Nyati, you are segueing into a third sort of angle on the basis of which you as an employer can find yourself before a court, dancing around and saying, no, I've done everything reasonable in my power. Where you have a clique of employees who have done the right thing, I think, and gotten themselves vaccinated to protect themselves, not only themselves, but also those around them, including their colleagues, probably families and friends and all of those things. You may find that you have a class action by those persons that say, well, we took the jab to protect ourselves and to protect you as colleagues, and you colleagues are refusing to take the jab to protect us back in return. And we think that the employer's approach in not forcing you to be vaccinated so that we're all protected and we can all join hands in protecting each other, attempting to protect each other. The employer is in breach of its obligations to create a safe environment and maintain a safe working environment for me as somebody who has taken that proactive step, So I think that is quite an important thing to think about as well, because I've only given about 2 examples of how you can find yourself before the courts, but these are all things that nothing stops any groups or class actions from actually approaching the courts on these issues to say, we have a right which is expressed as an obligation for you as our employer in terms of the Occupational Health and Safety Act, and we want it enforced. We want to be protected from the risk of transmission, even though we have been vaccinated, but we want to be sure that everybody that we do come into contact with at the workplace is actually also vaccinated, so that the risk is that much more reduced. So that, I think that's an important point to make. And then to come back to the question about the rights that the employees have. The employees have a right, of course, in terms of the Constitution, Dr. Nyati. There's a number of rights that come into play here. The right to life. Some people may, on the basis of the right to life, say, well, maybe taking the jab can actually risk my life. I want to risk my life. And in some instances, that may be correct based on the facts on the ground. And in some instances, maybe not so much. There is also the right to physical autonomy, which I think a lot of this is pegged on, really. Physical autonomy and bodily integrity means that every human being has a right to decide what happens to their physical being. And I think that right also permeates into the rights that are contained in the National Health Act. Section 3 of the National Health Act provides that for any medical treatment, medical procedures to be undertaken on a person or to be performed on a person, you require, as a medical practitioner, so trying to perform a medical procedure on a person, such as vaccination, you require the informed consent of that person. And that is really an extension of the right, as far as I'm concerned, of physical autonomy. Because before a doctor can give me a jab, I have a right to decide whether I want to get that jab, because this physical body belongs to me and I get to decide what happens to my body. So, the right is also expressed in a different piece of legislation, which I think presents an opportunity for employees to object to being vaccinated on the basis of the application of that right. There are other constitutional rights, such as the right to equality, and you've also got the right to freedom of religion, belief, and opinion, which is in section 15 of the Constitution. Now, in relation to the right to freedom of religion, belief, and opinion, also flows a number of other things, which includes sometimes just because of maybe the ingredients that are to be found in a specific type of a vaccine, people may, for religious reasons, object to consuming that. So, the easiest example to make, Dr. Nyati, from somebody who's a lawyer and not a doctor, layman by your word, by your terms, is if something contains pork, I think is the easiest example, or maybe components of pork, then it immediately excludes a number of religious groups from being take the vaccination and not feeling like you might be going to hell. So I think that the right to religion presents a very important impediment for employers, and a very important, I think, tool for some employees who belong to various religious groups to say, no, I'm not going to take this. Some maybe not necessarily because of what is contained in the ingredients and the components of the vaccine. Of course, it might be just, my religious beliefs tell me that I cannot inject myself with something like this, So for those number of reasons, employees may object. There are some also lifestyle-based objections that some employers might be likely to see. And here, you might find people, because of a choice of subscribing to a particular lifestyle and particular lifestyle habits, eating habits, consumption habits, and all of those things, you find that they object to taking things that have particular components,
Yes.
such as a vaccine might have from time to time.
Yeah.
So those are some of the competing rights that every single employer would have to grapple with in deciding whether it's reasonable for it to introduce a mandatory vaccination policy in its workplace. But those are some of the bases on which every employer can expect that some of its employees may object to taking the jab on the basis of. So people can say any one of those things. My right to physical autonomy, I don't want to do it. I have that right. Physical autonomy might also mean I need to give you my informed consent, so you need to tell me everything under the sun about this vaccine. And if you are unable to as an employer, then I'm not going to take something that you yourself cannot tell me what it contains, what it doesn't contain, what its possible side effects are, what they're not. And sometimes, obviously, something that, as you've mentioned, Dr. Nyati, does not give you a 100% guarantee that you will not be infected, but that can almost certainly give you a level of comfort with, even if you do get infected, you probably will not see the worst of the symptoms that some of the people have seen, and you probably reduce your chances of dying quite significantly. So from the employee's point of view, those are some of the things that employers will probably have to look out for in terms of what could form the basis for those objections.
Now, obviously, with all of those rights that are enshrined in our Constitution, the question then I will be asking you is, are they absolute? Can they be, under certain circumstances, can they be, overridden or limited, as in this particular situation? And if yes, under what kind of circumstances can, those rights actually be overridden or, limited? Yeah.
Okay, so the rights in the Bill of Rights, which I've touched on, physical autonomy, life, equality, religion, and all of that, are not absolute, Dr. Nyati. None of these rights are absolute. We have Section 36 of our Constitution, which provides for the justifiable limitation of any of the rights contained in the Bill of Rights. And the test really is about justification and reasonableness.
Yes.
So if it's justifiable and reasonable in an open and democratic society built on laws of general application, then you may limit a particular right. So, for example, the right to equality is somewhat circumscribed by our Employment Equity Act. We know that. So everybody has the right to equality, black, white, colored, Indian, but that right is somewhat circumscribed, taken away from by the provisions of something like the Employment Equity Act because of reasons related to the sad history of our past.
Yeah.
And the redress that we need to sort of set ourselves on as a path going into the future. And the same thing applies to the obligations that persons can raise to vaccination, where a law of general application deals with a particular right. So, for example, like the right to physical autonomy, and I've drawn the link for you between that right and the protections provided for employees and people in general in terms of the National Health Act, Section 3. You need a person's consent, informed consent, or you need to perform a medical procedure on somebody only if it is required by law. So that is, in and of itself, is already a limitation to the right to physical autonomy, because where the law requires it, somebody can perform a medical procedure on you, on your physical autonomous body, even without your consent. And that is a direct limitation of that right. So the right to religion itself is limited in the sense that where there's a law of general application that touches on religion, then that right can be exercised, but subject to certain limitations. We know we're a secular state, so employers may not punt one type of religion over another, in their workplace. And that in and of itself is a limitation to the right to religion in a way, because here's a company where the CEO is, let's say, Muslim, and would like to implement the Muslim faith on all of their employees. And sometimes, let's make an example and say Muslim people of Muslim faith cannot eat certain things, or by reason of their religious belief, which are genuinely held, which must be protected and respected in an open and democratic society. But you cannot do that. You have to allow people to, true to the nature of our secular state from a religious point of view, adopt whatever religious beliefs that they think are good for them. And that is a right that they enjoy, and that is a right that is very much protected by our constitution and our courts. So the same applies to applying a mandatory vaccination policy, for example, where if somebody has a constitutional right, let's say, to religion, and that is the basis on which the person says, because of X, Y, and Z, my religious beliefs and my religious faith, which I generally hold, precludes me from taking this vaccine, from taking the jab. A law of general application can limit that right in terms of Section 36 of the Constitution if it is justifiable and reasonable in an open and democratic society. And justifiable and reasonable goes back to the discussion we had at the beginning part of the session, where it is to comply with the obligation in terms of the Occupational Health and Safety Act. Yeah, sure, absolutely. An employer can take steps which may have the effect of, unfortunately, limiting your right to religion by having to ask you to take the jab. An employer may ask you, of course, to have to take the jab, which may limit your right to physical autonomy. Because you've got the right to physical autonomy. You can decide who does what to your body. If somebody thrusts a needle through your arm or not, it's a decision that you can take. But because of a law of general application, like the Occupational Health and Safety Act, which creates various obligations for employers and for employees, by the way, Dr. Nyati.
Yes.
The Occupational Health and Safety Act also creates obligations for employees. Employees are obliged to comply with all health and safety protocols put in place by their employers that are valid and binding. So that could in and of itself be a limitation to the right to physical autonomy, where an employer has in place a policy that is in the form of a mandatory vaccination policy. So absolutely, none of the rights that I've discussed are absolute. And the exercise that employers have to go through to substantively decide, well, for my workplace, do I want a mandatory vaccination policy based on the risk on the ground? Or do I not want it because I think the risk is kind of curtailed somewhat?
Yeah.
Those things do limit the rights invariably.
Yes. So now then, let's say the person is saying no to vaccination, but not using the rights from the Constitution, but is saying on medical grounds, I have a health situation that I believe can be exacerbated, worsened by me taking this vaccine. For example, I have a problem of clotting. For years I've been using tablets to help in making sure that I don't clot, because if I clot, then I can have a heart attack, I can have a stroke, and I now hear that this J&J vaccine has a tendency to actually increase the chances of clotting. And therefore, based on that chronic condition that I have and the published, adverse effects of this particular vaccine, I am not comfortable. I believe that it may increase the chances of me getting a stroke. Somebody who says that and can prove, they've got the reports from the doctors and everything that really proves that indeed he has a pre-existing comorbid condition that can be worsened by a particular, vaccine. Obviously, there's still a choice, because not all of these vaccines, do cause that clotting. AstraZeneca and J&J do have that, adverse effect, but Pfizer doesn't.
No, absolutely. I think the point of departure there, Dr. Nyati, is to understand that The obligations imposed on employers in terms of the Occupational Health and Safety Act are designed to protect life,
Yes.
and to protect the health and safety of persons while they're at the workplace, not to worsen it.
Yes.
So where somebody has comorbidities that are proven, they've got medical records to show that I suffer from this type of a comorbidity, which can complicate my life, should I be forced to take a vaccine, then the manner in which the provisions of the Occupational Health and Safety Act would be applicable to that person, at least in relation to that person in an isolated incident, would be such as to force the employer to do that which would advance the health and safety of the person rather than to harm it.
Yes.
So in that situation, then the employer's obligation changes and becomes, well, I may have a mandatory vaccination policy in my workplace, but in relation to those persons whose lives can be complicated rather than helped by taking the vaccine, I would have to adopt something different. And that flexibility and that level of flexibility exists and is quite recognized in our labor law, both in terms of the Labor Relations Act, in terms of the Basic Conditions of Employment Act, Employment Equity Act, and the Occupational Health and Safety Act. So there is a measure of flexibility in relation to how you are expected to apply these provisions as an employer in relation to trying to comply with your obligations in terms of the statutes per se.
So basically, you are saying somebody with a genuine, proven, medical condition, it could be seen to be reasonable, for that person not to take the vaccine, if indeed what they suffer from can be worsened by an adverse effect that is known, from that particular, vaccine. Now, before we get to the next point, there's somebody who has a comment. I'm going to ask my colleague, Nwamisa, to just ask that question. Hopefully, other questions can come as well. Yeah, Nwamisa, can you come in and pose the question from Masuku?
Okay. Good afternoon, Doc, or evening, and good evening, Mr. Masuku as well. We have one question from Julian Williams. He wrote, why should the words of the Honorable President be interpreted and not accepted as what he said? What about herd immunity? The fact that I'm vaccinated does not guarantee that I will get COVID-19. Thank you. That's it.
It's quite a cynical question.
Yeah.
It's quite a cynical question. I think the comment, the person who sent the comment must first realize that words must be ascribed meaning to. Whatever we say, whatever the president says, needs to be ascribed meaning to. And fortunately for us lawyers, that's what we do. We interpret statutes, we interpret the words, we interpret things, we give things their normal grammatical meaning unless it gives rise to absurdity. We look for purpose in meaning, we look for, what exactly was the intention of the person in uttering these words and what were they trying to actually drive across. And that is why the words of the president must be interpreted. Also another thing is that, we exist, through time. So, what the president says in 2010, might have to change in 2021 because of the different circumstances that are applicable in relation to both timeframes, So I've interpreted the words of the president, and I think a lot of people have, on the basis that, yes, he did say that no person will be forced to be vaccinated, but that was a while ago, and that was under very specific circumstances. And the circumstances have really morphed.
I mean, in the last, when he said that, it was around February, all right?
Yeah.
Before we got the vaccines from AstraZeneca that came from India. But
yes,
that's like a long
time. Before we got the third wave.
Yes, yeah. So, but since that time, there's so much that has happened. If he was asked to say something again, most probably he wouldn't say the same thing because the information, because this is a new disease and these vaccines are new, everything is new. Every day we're learning something new, so one has to be open to changing their position based on the facts that are, coming as this pandemic is evolving, and also as the vaccines are being, rolled out across the world.
Absolutely, and unfortunately, I say unfortunately, but it's not unfortunate. That's just how the cookie crumbles, to use that expression. We deal with life as it comes at us, and life may have come at us in February differently than it's coming at us right now, in which case we have to take different decisions from the decisions we may have taken in February under very different circumstances. But also, if I wanted to be cynical in answering the person's cynical question, I could also say that the president has actually not changed his stance on forcing people to vaccinate. All that has happened is that the president, the government in the consolidated directive has created a provision that expressly permits employers to implement vaccination policies, including mandatory vaccination policies. Now, the change in that some people can say is technical, but the change is I think is something quite important to take note of, because while we thought as government, we are not going to force vaccinate anybody, government is still not force vaccinating anybody. But government, in its capacity as an employer, for example, the Department of Basic Education, has different sets of obligations than national government, than even provincial and even local government. And we have not seen anything at national government, provincial, or even local government that says, we are going to go after you as citizens and say you must be vaccinated. The vaccination of persons as in their capacity as citizens is still very much on a voluntary basis. Yes. And really what has changed is from an employment landscape. And there is a reason behind that. And the reason is what we've been discussing for the better part of this session, which is the obligations that rest on employers to create and maintain safe working environments. I mean, you can only imagine if we didn't have such an obligation for employers, what would happen. You could break your back at work and not be in for any kind of payment or compensation, or your employer could be looking to get away with not being held liable at all for anything. So it's quite important for us to have these legislative provisions and to enforce these obligations on employers to ensure the protection of the very same citizens who become employees to those businesses. It's a very complicated way of answering a cynical question, but that's just how the cookie crumbles. Life comes at us differently at different times, and we have to respond to it differently as per the circumstances and facts that are applicable with the different circumstances that we face.
Yeah. All right. So let's move on from that. And normally at the workplace, especially where there's organized labor, there would be, consultations, between the employer and, the employee representatives or the union, obviously we're talking consultation, which is different to negotiation.
Absolutely.
So in this particular situation, are there any expectations that before the employer can, implement such, a directive, they need to have some agreement with, the employee representatives or unions?
So the first thing to note in that regard, Dr. Nyati, is that implementing a new mandatory vaccination policy for your business would occasion a change in terms and conditions of employment for your employees.
Yes.
And then the question becomes, how does one, from a labor law perspective in South Africa, implement a change in terms and conditions of employment such as an amendment to a policy or an introduction of a whole new policy, such as a vaccination policy that never existed before? And it's very correct. The requirement in terms of the Labor Relations Act is that consultation take place with the trade union representatives, the workplace forums, if you have workplace forums, and with other groupings of employees, that have structured themselves for the purpose of negotiating on behalf of employees. So the obligation would be to consult. The obligation is not so much to negotiate, because while you might negotiate wages, if you wanted to introduce a policy that changes some term and condition of employment that in part rests within the management's prerogative, such as a mandatory vaccination policy, then consultation is sufficient. And consultation does not have to yield an agreement from your consulting partners, but you have to consult, to inform, to persuade, and if you get an agreement, then great. If you don't get an agreement, there are specific measures that you can put in place to go ahead with the implementation of what you've consulted with your employee representatives on, without necessarily having achieved their agreement. And in relation to introducing a mandatory vaccination policy, certainly my view is that an employer would have to consult, because it's an introduction of something new. A whole policy provides for certain terms and conditions of employment that didn't exist before. You will take a jab now when you didn't have to take a jab the day before yesterday. And consultation will have to be undertaken in that regard, in compliance with the provisions that deal with consultation in terms of the Labour Relations Act. And once that consultation is done, then there can be certain other steps that can be undertaken in the face of an objection by a majority of employees, or by employees, or some employees at least, to the introduction of the mandatory vaccination policy. And the long and short of that is that employers can end up in situations where they have to retrench employees who are unfortunately rendered, redundant to the operational requirements of the employer by reason of them not wanting to be vaccinated. Imagine a hospital, and you have a clique of employees who happen to be medical practitioners not wanting to be vaccinated when they're right in the forefront of the risk. And you are introducing a mandatory vaccination policy. And this is a ridiculous example to make, but I think it's an example that will make the point more clearer. You have people who are clearly at risk and who are clearly in the forefront of the fight, taking a decision to not, or to object to your introduction of a mandatory vaccination policy. Then you find yourself being stuck between a rock and a hard place, to use that expression, because here you have obligations that say create a safe working environment, maintain that safe working environment as a priority before you can even resort to PPE. And then you've got people who are saying, well, we are diametrically opposed to that. We don't want that. And they are right in the risk. So now you're grappling between your obligation and their objection. And you unfortunately find yourself as an employer having to implement that because of the operational requirements of your workplace. The operational requirements of your workplace are such that the risk is so high that you cannot do without a mandatory vaccination policy. It'd simply be unreasonable for you to think you can get by as a hospital without having such a policy. So then what you do is you get into consultation processes. And when you find yourself in a deadlock with that clique of employees who are saying, well, even though we're medical practitioners, we don't believe in the vaccine. And we don't believe that we should be forced to be vaccinated for work purposes. They will be superfluous to your operational requirements, those people, because you simply cannot have employees who are right in the forefront, who risk death every day when they come to work. Who risk infection, transmission, and death every day that they come to work, and possible death, saying that we don't want to do this. That stance, I think, would certainly be unreasonable, and I think that stance could justify an employer saying, well, my operational requirements are such that I only want employees who are prepared to be vaccinated, so that I can ensure that at least I have complied with my part of the bargain, which is the obligations I have taken on in terms of the Occupational Health and Safety Act. And insofar as you insist on not wanting to be vaccinated, then unfortunately, you are not in line with my operational requirements, and therefore I'm going to retrench you. Obviously, we know there is an often quoted judgment of Fry's metals, which I know Legacy you are aware of. But that judgment speaks about the case in point example of what I'm talking about. And there are some legal principles that are applicable to that type of retrenchment. You may not use that as a bargaining chip to say, you do this, and here's the carrot for you, or you do this, here's the stick for you if you don't, because then the intention there is really not to ensure that the operational requirements of the business are met, but the real interest from such an employer would be to ensure compliance with a new term and condition of employment that is being superimposed on its employees. So I think that is something that is quite important to keep in mind. But certainly, retrenchment could be in line for those persons. In some instances where the facts and circumstances are right, you could probably find yourself as an employer being able to say, I'm going to dismiss you for misconduct, actually, for refusal to follow a reasonable instruction. Because then the question becomes, well, is this instruction reasonable? That I must comply with a newly implemented mandatory vaccination policy? And if the answer to that question is yes, if the instruction is also valid and legal and lawful, I mean, then if you refuse to comply with that instruction, you might be in trouble from a misconduct point of view. You could also be in trouble with that in relation to incapacity. Something often referred to as supervening incapacity or something along those lines, because maybe by your refusal to take the vaccine in circumstances where your coming to work means that the employer has to stress out about your risk of infection, transmission, and possible death because you are in the forefront. It could be that you are incapable of performing your job functions without forcing the employer to be in breach of its obligations in terms of the Occupational Health and Safety Act, in which case then you're incapable of performing, you're not vaccinated, we can't have you out there in the forefront because the risk is just too high for us. We don't want to be visited with the stick or the punitive measures that are provided for in terms of the Occupational Health and Safety Act, just because you are unreasonably refusing to do something that we think adds to our compliance with the obligation to create and maintain a healthy and a safe environment at work that is free from health and safety hazards. So yes, there are some risks for employees in that regard.
So in simple language, the law properly implemented, you could actually be dismissed by the employer for refusing to take a jab if they've introduced a mandatory vaccination policy in the workplace. Bottom line.
That is a possible risk. And it could be on the basis of any one of the three reasons I've discussed. Obviously, the Labor Relations Act recognizes three reasons for a fair dismissal, and that is misconduct, incapacity, which might relate to ill health or poor work performance. In this case, it would be supervening incapacity and operational requirements, which is retrenchment. So any one of those boxes gets ticked, you might be, in line to be dismissed if the circumstances and the facts are right.
Yeah. All right. So I'm happy so far. I'm not sure why we're not getting more questions, but it's okay. I want to get to another space now, or maybe just two questions here. Yes. So up until now, some employees of government could apply to the employer, that is the department, to say, I am suffering from these comorbid disorders. I would like to work from home. Okay. And so the employer has been allowing that because people have proven that indeed within the list that was given by the National Department of Health of comorbid disorders, this person has got end-stage hypertension, affecting the kidneys or whatever, So they were getting that privilege of working from home. Now they choose not to take the vaccine. Can the employer now say, well, I am taking that privilege away because there was something that was going to protect you should you get infected. And you now have chosen not to vaccinate. So you now have to come to work. Can an employer do that?
So in the situation where the person suffers comorbidities and that is identified as a risk, to their health and a risk to their life, if they should take the jab, then the explanation I gave earlier would find application because the life of the person, the health and safety of the person is a matter of primary consideration, even to taking the jab. So if taking the jab could risk the person's life, could risk deteriorating the person's comorbidities even further, risking death even, or severe illness, then the reasonable thing to do for an employer is not to force that person to vaccinate, because that would go against the health and safety. Now, coming to the situation where they work from home, and they've been given that as a privilege by the employer, and they have the comorbidity, and they refuse to be vaccinated by reason of the comorbidity. I would opine, my view would be that such an employer would find it very difficult to have to force such a person to come back into the workplace if that privilege has been extended to the person, purely because of the fact that taking them back into the work environment would not improve their health and safety matrix, but it would actually make it deteriorate. Because here's a person with comorbidities, is afraid of taking the jab because of the comorbidities, is working from home, and therefore is a safe.
No. The person has got a comorbidity, asthma, okay?
Yes.
You know that somebody who's got a pre-existing problem like an asthma, should they get COVID, then it could be serious. But now, if we give you a jab, then that risk of catching the infection reduces. But you choose to not
to take it.
And so now, as an employer, can I then say, well, we gave you the privilege and you chose not to take it, because had you taken the jab, then we would have covered you in the possibility of you getting infected. Your risk,
and obviously your risk matrix reduces quite significantly as somebody with that type of a comorbidity. Sorry, I now get the question. Look, I think it would be a very difficult balancing act for such an employer to have to undertake, because on the one hand, you want to ensure health and safety for everybody, including implementing flexible working arrangements like having people work from home. But that is all within reason. It cannot be abused. It cannot be unreasonable. And where a person unreasonably refuses to take the jab in circumstances where that could even assist with their comorbidity, then I would think an employer would be within its rights to make certain demands of that person. Look, I think employers would probably find it very difficult to force the person to return to the workplace just as a punitive measure. But if there are operational requirements that require the person to be at the workplace, or if the person's levels of productivity are much, much higher at the office than they are at home, and they are almost sitting at home, on a holiday, having a tipple instead of actually being productive at the workplace, which is where they need to be, then I think a case could be made out for such an employer to say, we demand you come back into the workplace, we demand full productivity for you because we pay for full productivity. And insofar as you've unreasonably refused to take a vaccine that could have assisted you and protected you from possible infection, even if you were at home or even if you were operating from the office, then you unfortunately the author of your own misfortune should you get infected. But I think the balancing act comes in with that employer having to think about, well, hang on, if we do that, that person comes into the workplace and actually contracts COVID and God forbid dies, what then in terms of the obligations we have in terms of Occupational Health and Safety Act? And I think that that's what would complicate the balancing act for that employer, because I think you would want to save human life as far as you possibly can, rather than risk it just to be punitive, right? But at the same time, you still have a right to demand certain things of your employees, like the right level of productivity per day, because that's what you pay for per day.
All right.
So it would be a very difficult balancing act.
Yes, because when the 10,000 people who refused to vaccinate at GDE were announced, then there were some people, were saying then we will review those, privileges for some of the people who, have been working from home. And so your answer is actually quite good. Now, I'm going to take you in a slight detour. I'm going to put your head on the block here.
Okay, I like this part.
Yeah, so then you have a Chapter 9 institution that is called the South African Human Rights Commission. So
yes.
This past week, they have come out very aggressively to say they are, looking for people who, on the basis of them refusing to take the vaccine, they may be discriminated or threatened or whatever. So I just don't have the article now, but in essence,
yes.
They are looking for people, or they are calling for people who have experienced some form of discrimination or threats because they didn't want to take the vaccine. And they want to represent them, maybe a test case in the court or something like that. Can you just talk to us about that? Obviously, we don't want to compromise you here, and you are here in your personal capacity, not in the capacity of your firm, but
yes.
I just want your view.
Yeah, look, I thought it was quite interesting, actually, Dr. Nyati, when I saw that from the Human Rights Commission. I'll be honest, I haven't seen, the full article, or actually something that resembles an invitation, and what the wording in that invitation looks like for the persons to come forward to the Human Rights Commission to be able to represent them in those sort of cases, albeit that they may be test cases. But I must be honest, in the absence of having read anything directly from the Human Rights Commission on how they are looking to tackle this issue, I struggle to understand the link between an employer wanting to vaccinate its employees in an attempt to comply with its occupational health and safety obligations and discrimination. Because discrimination, as we know, is the unacceptable differentiation between persons, on a particular ground, be it race, religion, skin, all of those things. So
can I just read?
I suspect.
Can I just read this article?
Yes.
This is from Times Live, 27th
yes.
of July, 2021. Right. It says, the South African Human Rights Commission wants people who have been threatened with losing their jobs or rented accommodation for refusing to have a COVID-19 vaccine to come forward. Gauteng Commission head Muang Jones said they hoped this would get the ball rolling to determine the legalities around the issue. We are exploring all available legal options and would like to see how best we can address the situation with affected employees and the implicated employers, Jones told Times Live on Tuesday. All right. He also tweeted, the same Muang Jones, he tweeted on the 26th of July at 5 to 2 in the afternoon, if your employer has decided to make vaccination mandatory and you feel prejudiced by this decision, please send us an email to gautengcomplaints@sarhc.org.za. He goes further to say the commission is monitoring the rollout of the vaccines and has been encouraging people to take the vaccine. We've received complaints from people who have been told they will be dismissed or evicted from where they stay if they do not take the vaccine. These are people who have serious misgivings about the vaccine, and they have reached out to the commission. All right. So that's while the commission was planning to hear from employees opting not to be vaccinated and employers who need to deal with them, there have been calls for the commission to also hear from those with comorbidities exposed to the risk of infection by the unvaccinated co-workers.
Yeah, it's an interesting angle, Dr. Nyati, and I think the word there is prejudice. Employees who have been prejudiced by being forced to take the vaccine in circumstances where they do not want to or have objections to taking it. And I think it ties in right into the discussion that we've been having, in the session, because there are competing interests, no doubt. I don't doubt that one second. Employees have rights on the one hand, which must be protected, some of which are serious constitutional rights that cannot just willy-nilly be limited. But on the other hand, employers have obligations, some of which are serious obligations that have a serious consequences for non-compliance with those obligations. So the competing interests will play out in whatever litigation ensues from that invitation, come the time the Human Rights Commission has its first responders in relation to people who find themselves in those situations where they don't want to be vaccinated and their employer is threatening dismissal or something along those lines for their refusal to vaccinate. But I think, just like we've been doing in this session, Dr. Nyanti, the courts will find themselves having to grapple with the two competing interests, and the courts will have to find themselves having to decide, well, what is more important under the circumstances, taking into account, obviously, the circumstances on the ground. The employer would have a risk assessment. The risk assessment would identify risks, transmission, infection, even possible fatalities. And if those are high, and if the measures in place are not sufficient to satisfy that employer that, reasonably speaking, we've done what we can to protect our employees, then the courts will have to decide, well, is it okay? Is it reasonable for this employer to want to introduce something extra, a mandatory vaccination policy? On the other hand, the courts will have to decide, well, if we say it's reasonable for this employer, taking into account its specific effects and circumstances on the ground, to implement a mandatory vaccination policy, then what do we say of the employee's rights to object to that? And those two will have to necessarily be weighed up against each other. Yeah. And one of those two competing interests will unfortunately win. It's not going to be both. And I think that they will each be determined on the basis of their substance, and they will each be determined on the basis of the facts applicable on the ground and how high the risk is, what is the risk matrix, what is the plan that the employer has put in place, and to what extent is that plan an attempt to comply with the obligations in terms of the Occupational Health and Safety Act. And if it is, well, then you cannot excuse an employer from complying with its obligations in terms of the Occupational Health and Safety Act. And if the obligations call for, reasonably speaking, the introduction of a policy, then that will probably take precedence.
Yeah. All right. Wow. Okay. This has been, for me, a nice, lecture. Like the many hours we've spent in the past, when I've got these kind of cases as an employer. So I've been empowered greatly, and I hope the people who joined in, despite the fact that there's only one person who sent a question, but I know there's many who are following on Facebook, who are following on YouTube, and I hope that some of their questions have been answered, because you really unpacked things in a way that is very simple for some of us who are lay in your space, so I think people must think twice, about their stance on this issue of vaccination, because they may actually lose their job if the employer has done things according to book. They may lose their jobs, and in this environment where unemployment is very high and it's very difficult to find jobs, one has to weigh that risk, to taking that stand of not being vaccinated. But there's also another indirect situation, though. Let's say somebody works in an airline, and therefore they have to travel to different countries of the world, right? Work for SAA or, any other airline. Now, whilst we may say it's voluntary here, but to be able to do your job and get to the UK, get to America, get to Israel, you need to show proof that you've been vaccinated, and not just vaccinated with the vaccines that are approved by that particular country.
Absolutely.
So if you are not vaccinated, then it means you can't do your job as a flight attendant or as a pilot. And so, whilst South Africa may give you the option, of this being voluntary, but another country where you land may not give you that option. And then what happens there? So I think there are a lot of issues. So the issue of vaccination passports is now a big issue in the European Union and also in the US. So I think people, if you work, for example, for it used to be called Foreign Affairs, I don't know what they call it now, and you're going to be deployed in America, and they want you to be vaccinated. Can you say no? I'm not going to be get vaccinated, and your employer wants to place you in New York, or in Washington. So I think there are a lot of considerations that people need to make, before they take a stance like that. But I'm looking forward to, I'm looking forward to a test case, in court about this matter.
Oh yes, we lawyers are waiting in glee to see what's going to happen, and how the Constitutional Court, a lot of these disputes obviously start in the High Court and make their way up all the way to the Constitutional Court. But in some cases, of course, people like the Human Rights Commission can apply for the right to direct access to the Constitutional Court, because they may argue that a direct constitutional issue is being invoked here. A constitutional right is being trampled on and all of those things, and they may, in the right circumstances, get that right. But I think we were all waiting excitedly to see, what happens in the legal landscape around this issue. And I think, by the way, that's a classical example of how the operational requirements can actually chuck you out, to use that expression, as an employee. Because if you say, for example, America right now, the United States is one of those countries that say we require everybody from South Africa flying in here to be vaccinated and provide proof and have a vaccinate passport. Then it would be certainly within the employer's operational requirements to compel you to get vaccinated if you are going to be flying overseas or being placed overseas on a project or something along those lines. And if that is going to be in the United States, and that is what the United States requires from South African travelers. And you unfortunately find yourself having to make a difficult choice as an employee of, well, do I do this, go to the US, or do I not do this and not be able to go to the US? In which case, I think the business case for the employer looking to retrench that person becomes that much easier. Because if you're not vaccinated, you don't have a certificate, then you simply cannot travel to that country, and therefore we cannot employ you for this purpose. And it becomes as simple an issue as that. But I agree, it's been quite an interesting discourse. And I've thoroughly enjoyed it myself as well. Thank you.
Yeah, we've got a comment here from Dr. Let me see now. A comment from Zanele Stebe, who says, "Thanks, Mr. Masuku. This was a very informative talk." So, confirming what I've just said, that you managed to bring the discussion to our level. It was relatable. It was easy to understand, and I think many of us have been empowered. And it's not an easy thing when you are a professional, any professional. To have to try and simplify things when you are used to talking to your owner and whoever and use big language,
including a lot of Latin, legalese.
Exactly. But anyway, in the absence of any further questions, on my side, I'm very happy, and thank you very much. I know you had to go to a situation, a family situation earlier. I'm not sure if it's a family or a friend, but basically you had to attend a funeral earlier. And for you to come back and switch to, the professional, mode, it's not an easy task. So thank you very much for, agreeing under those circumstances to come and share with us. It's always nice to see, young, up and coming professionals taking up space,
occupying space.
Yes, in South Africa, we have a situation where there's a generation that just doesn't want to go on retirement. And
picking on the old people again, Dr. Nyati.
Yes, so I think we need young people to occupy spaces and actually take leadership of many aspects of this country. They've had their chance, and I think it's the chance of young people. And I'm happy, I've known you for a long time now, and I'm very happy, with the progress, you've made, and you've been an acting judge as well recently.
Oh yes.
So
that was quite an experience. Sure.
Yeah, but anyway, thank you very much, Babu Masuku, man. Go and rest. Have the rest of your Saturday. Just unwinding, and looking forward to chatting with you again when there's another legal issue that involves employment law.
Oh, thank you very much for having me, Dr. Nyati, and I'm thoroughly grateful for the comment from the person that sent it. I hope I've spoken in a language that can be understood. We do tend to speak as if everybody's a lawyer, but that is a bit of a struggle, I suppose, with every practicing attorney to have to try and cut down the legalese and bring things, to the audience. But thank you very much for having me. I thoroughly appreciate it. And I thoroughly enjoyed the session too.
Thank you.
All right.
Bye. Thank you to everybody who joined us, and I really trust that you found that discussion quite useful. And if you want to share, we've got the clip on YouTube. You can go to the Dr. Fundi channel on YouTube, and then you'll be able to get this clip, and you can share it with those that were not able to watch because they are watching the Springbok game that started at 6 o'clock. So with those words, thank you very much. We'll be back tomorrow at 6:30 in the early evening. It's the 1st of August 2021. It's a Women's Month here in South Africa. So in this channel, we normally celebrate women who are doing great things in their chosen fields. So we have an interesting guest that's coming up tomorrow, who is an expert on matters of governance, compliance, and ethics in the corporate world. We look forward to welcoming her here tomorrow at 6:30 in the evening. And she will tell us about her journey to the top, breaking those glass ceilings in environments that were previously, occupied by men. Let's meet tomorrow, 6:30, as we start to celebrate the women of South Africa. And we'll be doing that for the rest of the month. So I will not have any male guest during the month of August. I will just be celebrating, and profiling different women who are doing great things in South Africa in their chosen profession. It doesn't have to be in the medical field. People are doing great things in whatever field that they have chosen. So thank you very much. Let's meet tomorrow at 6:30.